morning, my name is Donatella Ita and I'm a PhD student in the Human Rights Program at the University of Deusto. The small presentation I am about to start focuses on a specific part of a more extended research which covers the right to reparation for victims of international crimes in the International Criminal Court. The presentation focuses on the correlation between individual criminal responsibility and individual civil liability, that is to say, reparation for victims. The presentation is divided in three sections corresponding to the concepts to be considered for the dissertation, and they are the existence of hierarchization of the responsibility forms in the statutes and practice of international criminal tribunals, that means the development of a responsibility system based on the seriousness of the crime, proportionality of the punishment with a specific contribution in the perpetration of international crime, and this permits to have a conceptual ground to affirm the existence of the principle proportionality from which infer the consistency between criminal responsibility and responsibility for reparations, especially where the former is in the form of an accessory liability and the responsible did not cause the totality of harms. This gives a light on a specific element connected with the more general issue of the role of victims in the International Criminal Court proceedings. In general, it is possible to identify two legal models for the evaluation of individual criminal responsibility, both at national and international level, the unitary perpetrator model and differential participation model. According to the first theory, all persons who participated or contributed in the commission of the crime are considered guilty as principal offenders. The differential participation model, on the other hand, distinguishes between the material perpetrator and secondary parties, whose responsibility terms are generally divided in subcategories. Both models have been implemented by statutes and practice of international criminal tribunals. At Nuremberg trial, the practice shows a global view of the action of the perpetrator of the international crime, as well as there was no formal distinction between, for example, a war crime and the crime against humanity in terms of seriousness, and formally rejects the idea of a hierarchy among crimes against humanity and war crimes. The practice of an International Criminal Tribunal for former Yugoslavia, International Criminal Tribunal for Rwanda, highlights more attention to the existence of a responsibility system. Through these considerations, it is possible to state that, even if it does not exist a prima facie hierarchization between international crimes, it works de facto on the establishment of the sentence and, as a reflection, on the establishment of the accused's liability. At this latter level, it seems to be recognized the contribution of the accused to the crime as a key element of the sentence. Finally, it is possible to identify a seriousness hierarchization of the responsibility forms, at least at conceptual level. The International Criminal Court Statute at Article 25 deals with individual criminal responsibility, and the paragraph 3 categorizes the responsibility establishing different forms of perpetration: solitary perpetration, co-perpetration, and intermediary perpetration. The article does not assemble in the same paragraph instigation, aiding, and committing a crime, but categorizes the three and adds in separate points otherwise supporting and inciting. The willingness to and the structure aimed to strictly separate different forms of liability could be considered a sign of inclination to a hierarchy system. Article 25 of the ICC statute, therefore, creates a range of modes of responsibility based on the forms of participation from which the court may choose from. In this sense, the statute embraces a sort of differential participation model, where the court is not apparently obliged to differentiate in the sentence the degree of responsibility. However, Article 75 of the Rome Statute identifies as a factor in determining the sentence the individual circumstances of the convicted person, which could feasibly include the degree of participation in the offense and damages caused to victims. On this record, the recent practice of the International Criminal Court did not take a definitive and uniform view. The issue of the distinction principal-accessory responsibility has direct impact on the rationale of the punishment. The statutes of Nuremberg and Tokyo tribunals deal with the definition of accomplice in a general way that seems to embrace the unitary model without distinguishing between principal and accessory perpetrators. More than 40 years later, the ad hoc tribunals for the former Yugoslavia and Rwanda adopted a general definition of accessory responsibility, which makes it difficult to identify the embraced model of accomplice responsibility. However, there are some cases before the two tribunals providing a certain relevance of the formal liability for the sentence. As a general remark, it is possible to identify in the ICTY and ICTR practice the will to preserve the discretion of the judge to determine the sentence and the evaluation of the contribution in the commission of the crime. Regarding International Criminal Court, once it has been established the order of gravity in the responsibility system of the statute, the consequence is the principle of proportionality in the meaning of the establishment of an appropriate sentence according to the specific contribution of the accused. The consideration results from the interpretation of the article of the ICC statute which deal with the issue of the appeals of the sentence. Namely, the Article 81, paragraph 2a includes as one of the reasons for the appeal the disproportion between the crime and the sentence as an autonomous hypothesis of appeals. The article is linked to the Article 83 with reference to sentences of conviction and provides the court with the power to vary the sentence in the case it is disproportionate in respect to the crime. In this way, the principle of proportionality of the punishment raises to guiding principle for the reassessment of the adequacy of the punishment on appeal. It must be remarked that the principle of proportionality at this point is closely linked to the principle of legality, in the sense of determination of the criminal behaviors to which the law or sentences correlate the same disvalued treatment. Additionally, the principle of proportionality is linked to the principle of equal and fair treatment, and it improves one of the fundamental roles of the criminal sanction, that is the general prevention. Finally, it is necessary to stress the role of an appropriate classification and sentences according to the specific contribution of the accused in the truth-telling function of the criminal law system. The case law of the ICC confirms a basic distinction between principal and accessory liability, at least at the conceptual level. The major expression of the ICC position thereupon is the appeal decision in the Lubanga case, where the Chamber distinguishes between the two forms of responsibility, stating that it contributes to a proper labeling of the accused person's criminal responsibility. The last issue is to establish the consistency of the criminal law accessory responsibility with the law of tort, in other words, with compensations for victims. In general terms, it seems logical to make civil liability arise from the criminal liability. But international courts find hard to accept this connection due to a widespread application of the joint criminal enterprise doctrine. Nevertheless, it is possible to provide different elements in support of the correspondence between criminal and civil liability, both subjective and objective. Firstly, civil liability requires a lower standard of proof, identified in the balance of probabilities, whereas the criminal responsibility must be proved beyond a reasonable doubt. In this sense, once the criminal responsibility has been established, it should work as a legitimation and complementary instrument for victim compensations. Furthermore, international and national courts often support a collective liability greater than proportionate responsibility by virtue of the principle of fairness towards wronged victims, in the case that the principal perpetrator is not able to recover damages. But it is equally unfair not to take into consideration that the responsibility of an accomplice may be of a less degree than that of the principal. The strict link between criminal and civil liability may depend on the mode to establish the responsibility of the accessory. The accessory criminal responsibility, as the civil liability, may be imposed despite the absence of the principal, for instance, in the case this latter has a special defense. A further element of consistency could be found in the modes of contribution to the crime, or tort. They are actually different, but the requirements necessary to establish accessory liability under criminal law are more stringent than those in civil law are. In this sense, the criminal liability resulting in a tort should lead to the consequent tortious liability, at least by inclusion. Some author invokes an inherent distinction between criminal and civil law in the different terminology used to refer to the crime and tort responsibility, but the linguistic element cannot underpin such distinction, as it is flexible and lacks of universality, to be set up as essential factor of this differentiation. The debate about the accomplice's responsibility in International Criminal Court arises from a lack of explicit provision in the Rome Statute asserting the proportionality of the sentence according to the contribution of the accomplice to the wrongdoing. However, the consistency could be easily inferred from the same statute. The rule of procedure and evidence is the first in establishing that among the factors to take into account with purpose of the sentence there should be the extent of the damage caused, in particular the harm caused to the victims and their family, and the degree of participation of the convicted person. The reference to damages and the degree of participation creates a close link between the responsibility as determined in the sentence and the amount of compensation in the sense of proportionality. The Rule 223 of the Rules of Procedure and Evidence, within the framework of the enumeration of the criteria for the reduction of the punishment, considers any impact on the victims and their families as a result of the early release. At a more general level, it is important to remark that only some of the international documents dealing specifically with the right to reparation reflect the principle of proportionality between the remedy and the harm. The Principle 15 of the UN Basic Principle and Guideline on the Right to Reparation envisages that reparation should be proportional to the gravity of the violation of the harm suffered. The trial chamber of the ICC in the Lubanga case chose this option in the judgment. The chamber indeed asserts about the necessary consistency between the contribution of the convicted and only those crimes he or she has contributed to. In the appeal decision in Lubanga, the chamber records the general principle of proportionality between damage and reparation as a rule generally accepted in international law. More recently, the Lubanga Appeals Order on Reparations stated that the scope of liability for reparations might differ depending on the mode of individual criminal responsibility established on the specific elements of that responsibility. In the Katanga case, it is recalled that the scope of convicted person's liability must be proportionate to the harm caused and, inter alia, his or her participation in the commission of the crimes, of which he or she was found guilty in the specific circumstances of the case. The principle has been embraced also in the Almadi case related to crimes against cultural heritage and protected objects. The case law direction undertaken by the International Criminal Court has undergone a change of direction with the recent decision of the last year to appeal the order on reparations in the Katanga case. The appeals chambers indicated that, for the amount of reparation for which a convicted person is held liable, it is in principle irrelevant whether other individuals may also have contributed to the harm. The primary consideration is the extent of the harm and the cost it takes to repair that harm. Criteria such as the gravity of the crimes or mitigating factors are not relevant to these questions. As final remarks on the ICC practice, it is possible to state that within the limits of the purpose and object of each type of responsibility, it could be highlighted the necessary consistency between the criminal and civil liability, and that it is established in the ICC practice. The recent decision on the Katanga reparation appeal on the one hand confirms and clarifies some milestones of the reparation procedure before the ICC, and on the other hand demonstrates that the issue of the scope of civil liability of secondary perpetrators lacks of sufficient conceptual elaboration. At the same time, it demonstrates the substantial and practical nature of the issue on victims' rights. Reparation and their application in accordance to the criminal responsibility permits to reach the universality the previous international judicial experiences aim to. It allows as well confer consistency to the reparation system before the International Criminal Court in order to make it automatic and efficient. Once the connection between criminal responsibility and the effectiveness of reparations at judicial level has been demonstrated, part of the solution to the legitimacy crisis that has put under pressure the ICC in the recent years is the creation of a uniform and coherent reparation practice. In perspective, it is possible to state that reparations are also necessary to ensure respect for the statute, providing automaticity to the reparative system as an essential characteristic of a mechanism that, by its nature, surpasses any preventing function, being intended to act at the moment following the occurrence of the damages. The whole of these elements enable the court to guarantee appropriate attention to harm suffered by victims and to strengthen their position in the criminal proceeding. Within the limits of its relevance at the sentencing level, the principle of proportionality makes it possible to reduce the distance that, for different reasons, is creating the ICC system between the convicted persons and the victims, allowing reparation to be applied with its own restorative character, away from any punitive effect. On a more general level, it infers on the perception of justice that it needs either distributive justice, that refers to the justice of results, and procedural justice. In the first of the two levels, it implies the proportionality of the sentence with the respect to the gravity of the crime committed, while in the second level, it establishes the proportionality of the reparations with respect to the contribution to the crime. This translates into the idea of something we can define distributive reparations, which are linked to the justiciability of the right to reparation, as it relates to its application in the proceeding as a guarantee of justice. Within this framework, what matter, then, are the practice and the solution that the court provides in each case with its particularities, far from theoretical lens. The court has all the elements necessary to uniform its interpretative direction towards the correspondence of reparation with the form of criminal responsibility, assuming a remedial perspective. It would be, therefore, an executive and procedural principle, in light of the principle of proportionality, that originates directly from the case law and from the need for protection, giving value to what the position of victims actually represents before the ICC, that is, a protection interest that is concretized in the remedies accorded to it. Thank you for your attention. Please, if you have any suggestions, comments, or advice, feel free to share them with me at my email address.